Chapter 9. Appeals. 1. The first appeals were to Moses, Deuteronomy 1:17, Exodus 18:26. Later they were to the priests, Deuteronomy 17:8-12, 19:17. In later history in Israel, appeals were to the king, 2 Samuel 14:4-11, 1 Kings 3:16. Still later, in Christ's time, they were to the Sanhedrin. The premise that undergirds and requires courts of appeal is man's sin and fallibility. If we assume that the best men are our judges, we must still take their status as men for granted, not all-wise, not sinless, and not infallible. In both church and state, this elementary premise is gone. Appellate courts are no longer concerned with reviewing the case in terms of its rightness or wrongness, but only in terms of its procedural correctness. Churches that claim to be orthodox refuse to reconsider a case as to whether or not justice prevailed, but only to see if proper procedures are followed. This means the lowest court can commit flagrant injustice and be sustained in it, provided the procedure is correct. The review of appellate courts in church and state thus rests on a peculiar premise. First, by refusing to examine a case as to whether or not injustice prevailed, the courts of appeal assume the infallibility of the lowest court. Second, by accepting a case on appeal, they assume that a procedural mistake occurred. How can a decision be immune to appeal on the grounds of injustice and yet subject to retrial on procedural grounds? Often, the procedural grounds involve trifles, nothing relating to justice. Such a state of affairs is only possible when justice is no longer essential and only, quote, the dignity of the court, end quote, matters. It is not at all surprising that this change from justice to procedure has coincided with the growth of the modern power state. It makes the modern power state immune to the technical status of fallibility, but preserves it intact in its arrogant autonomy. The courts in this perverse state deny at the same time any higher law and the God who gave that law. They thereby deny that any law or morality exists above and over the state, whereby the state can and must be judged. The rejection of God enables the state to play God. Not surprisingly, the older system of local, county, state and federal courts has steadily given way to bureaucratic controls. This does not mean that the older system, now radically humanistic, is good, simply that the new bureaucratic courts are more efficient in their tyranny. The choice is always between God and tyranny, although sometimes, given man's tyranny, we get tyranny in the name of God and justice. When we get such an evil state, we have an obligation to work for justice by prayerfully working to restore all men and institutions to their rightful place under God and His Christ. In Deuteronomy 17:8-12, it is important to note that, on appeal, priests and Levites are to take part in the proceedings as well as the judges. Because justice is a moral and religious fact, the presence of experts in God's law is a necessity. The meaning of an appeal is gone when justice is not a moral consideration. Because of the Christian impact on the whole world, even Marxist nations have ostensible appellate courts. These, however, are unconcerned with justice, and their function is a facade whereby the form is observed and the substance gutted. In Luke 18:3, we read of a helpless widow's cry to a judge, quote, "Avenge me of mine adversary." This is a cry resounding over the centuries in millions of voices. Even worse, churches which should uphold the sovereign and triune God and His law deny that law. By doing so, they have joined the unjust judge and are adversaries of Jesus Christ.